SJC-11361, Commonwealth versus Gulla.
Mr. Maidman, good morning.
Good morning, Your Honor, and if it may please the court. What I'd like to proceed by discussing the ineffective assistance of counsel issue first, and then in whatever time remaining, briefly touch on the denial of the manslaughter instruction. Let me begin by saying this case is a tragedy both for the victim and for the defendant. The facts are, it's a horrendous case. The issue is whether the defendant received constitutionally effective assistance of counsel. And the facts are largely not in dispute. The defendant's counsel conceded properly, in my view, in his opening and closing argument that this is not a whodunit case that the defendant killed the victim. The question is whether the defendant received effective assistance of counsel when his lawyer forego presenting a lack of criminal responsibility defense.
Can I ask you about that? Because as I read it, he certainly investigated the possibility of it, and he had 3 experts, all of whom would not opine as to this. How is he supposed to do it?
How is he supposed to present the lack of criminal responsibility
Yes,
defense?
without expert testimony.
Well, the law in Massachusetts is clear. You do not need a doctor to present a lack of criminal.
But I mean, in terms of a viable defense. I mean, isn't it kind of tough to do when you're going to not have somebody to put on to say that they, in fact...
It's certainly tough to do. On the other hand, the facts of this case were so horrendous that the jury had to be waiting at the end of the case for where is the insanity defense. I mean, all the defendant have to, you can imagine a scenario where the defense counsel gets up and let's put to one side what the testimony would be. But the defense counsel gets up with the Commonwealth's own pictures and says, look at this. Is there any doubt, do these pictures raise reasonable doubt that this defendant was not sane? So it could have been presented. And at the evidentiary hearing, I asked the defense counsel, were you aware you didn't need a doctor? And he said yes, and Judge Billings made a finding of fact on that specifically. So it could have been done. I'm not saying it would have been easy, might not have worked, but it certainly would have been a better defense than what was actually done in the case. And by the way, let me be clear about one thing.
Are you saying better because it didn't succeed?
No, I'm saying, and this is without hindsight. Take out the hindsight from this. I'm saying it not only would have been better, but it would have been, looking at this right from the beginning. The reason he got 3 doctors was because you can infer this from the record. He got 3 doctors because he couldn't believe that this guy did not have a viable lack of criminal responsibility defense. He didn't testify to that, but one can infer that. So he went through doctor number 1, and there was a little more to it. In the beginning of the case, there was some question whether the guy was even competent to stand trial. And ultimately, he was found competent to stand trial. But again, and let me be clear about another point. The defendant is not saying that the defense counsel was constitutionally incompetent by presenting a mental impairment defense. I mean, that was something he had to work with. Because he had, if no other reason, he had a doctor who was willing to testify to that. On the other hand, what the defendant is arguing is that based on the facts of this case, and the record is absolutely clear just how horrendous it was, he could have reasonably presented a lack of criminal defense, responsibility defense, and it might have been successful.
So you're saying that if there's evidence that would support a lack of criminal responsibility defense, that the attorney is ineffective unless, all strategic judgment aside, he or she puts on that defense. Is that your position?
It's not, I would suggest it's not that clear. It's based on all of these cases. Anytime you're dealing with ineffective assistance of counsel, as this court well knows, they're very fact-specific. He went with the mental impairment defense, which basically means you're arguing to the jury, and we get into just how well he argued it. You're arguing to the jury that this defendant did not have because of mental impairment, or alcohol as the case may be, this defendant could not formulate the mens rea for the crime, or the knowledge aspects, for example, with extreme atrocity and cruelty. That is a very difficult claim to make. And if you look at the jury instructions...
More difficult than insanity?
I think it's more, yes, I would suggest that it is.
But
Again, it's what does a reasonable lawyer do? The reasonable lawyer, looking at this case, when he first got the case, the facts were such that it was terrible what happened to this victim. There's no question about it. The record is clear. There's no factual dispute. I'm sure take a look at the Commonwealth's brief. They went on and on and on about just what this defendant did to this victim. I mean, essentially, he tried cutting off her head. And by looking at these facts, a rational jury would certainly entertain a lack of criminal responsibility defense. And
What makes you say that? What makes you say that? Because
penalty of the crime.
I mean, that's
all murders are. I'm sorry.
Yeah. What makes you say that the jury would be interested in hearing this evidence and would be receptive to it? Where do you get that?
I get that from I get it from the record, quite frankly, and the pictures and everything else. It is such that this is so far beyond, I would suggest the record shows it is so far beyond the typical murder case.
So what
With
about
the
the
brutality-
Rosenthal case? What about that case, Rosenthal, where
Stuck his head on a spike.
That
was pretty.
Okay, so there was a guilty verdict. The jury rejected insanity.
Ineffective assistance. That's right. Ineffective and insanity defense is always difficult. I don't want to downplay that either. But the question is, what does the reasonable lawyer do under the circumstances? What is the range of reasonable performance? And under these circumstances, given what he knew at the time, he should have asserted a lack of criminal responsibility defense. And the defendant was prejudiced by that.
Now, what do we do with the fact that Judge Billings was the judge at trial, and he said that his performance was more than adequate?
Well, he did say that. He also said that if he had been asked for a lack of criminal responsibility instruction, he would have given it, or he might have given it. I don't want to put words in his mouth either. You look at what he did, as far as he went. The problem is he did not do what he could have done. And I'm suggesting to the court that reasonable attorney performance, doing a murder case in Massachusetts, demands more. And that's what should have been done in this case. And the record supports that.
I didn't quite get what your response was ultimately to Justice Hines's question about just because there's evidence of it, you don't have to take into account the attorney's strategic considerations. I mean, you're saying this lawyer was ineffective because of the strategic decision he made not to do this.
Manifestly unreasonable. Manifestly
I think
unreasonable.
it's manifestly unreasonable.
Not to do that under the circumstances of this case.
Only in the circumstances of this case.
Yeah,
Not just more broadly whenever there's
no,
evidence to support it.
You're correct. Under the facts of this case. You can't just say, well, you must always present a lack of criminal responsibility. For one thing, the defendant may not want to present one.
Right. And do we know
That's
anything about that?
That's always in play.
Do we know anything about that here?
It's not in the record.
There's nothing in the record about whether the defendant wanted or didn't want it.
No.
He didn't testify. It's Mr. Galvin, right?
Say again?
The trial lawyer
Was John Galvin, that's
yes.
correct.
Did he didn't say anything on the motion for new trial about what the
No, not at
defendant
all.
wanted or didn't want?
Not at all. No,
Did he talk, because I didn't read this, but did he talk at all about his view of the general success rate of lack of criminal responsibility?
I don't remember. But the thrust of his testimony was, well, I went out and I thoroughly investigated, and there's no claim he didn't investigate this. I thoroughly investigated. I couldn't find a doctor who would testify to it, so I went with what I had. And what I'm suggesting is, not based on hindsight, based on what he knew at the time. But there was a reason he went looking for 3 doctors. Why? Because this was overwhelmingly a lack of criminal responsibility defense. He didn't say that, but one could certainly infer that from the record. But again, this case is limited to its own facts. I mean, I should make that point. It's limited to its own facts, as is any ineffective assistance to counsel, essentially any ineffective assistance to counsel case. But again, the facts are so over the top that not to present it, I believe, was attorney incompetence under the Sixth Amendment in Article 12.
Okay, thank you.
Let me move on and briefly address the second component of ineffective assistance of counsel, and that is his closing argument. What he did was he basically went through the evidence at trial. And then in the last, and this is like 18 pages, and then in the last part of his argument, he mentions mental health issues. I mean, he did talk about how the guy had Asperger's and how he didn't have, lots of friends, and all. I mean, he had a flat affect, and just over the course of 18 pages, he got that in. But if you look at page 21 of volume 11 of the transcript, which is May 30th, it's the last paragraph. Essentially, this is what he says. The judge is going to instruct you on the law. He acted in rage. There was no ability because of his mental impairment and his alcohol intoxication to form that premeditation. Note he never said anything about extreme atrocity and cruelty, which is the most, it's certainly one of his two one of the Commonwealth's 2 theories of prosecution. As you consider his level of responsibility, I suggest to you that the Commonwealth has not met its burden to prove beyond a reasonable doubt murder in the first degree. And it goes on a little and says, I suggest to you he could not control his behavior that day. This lawyer had lots of stuff to work with. Okay, aside from just recounting all the drinking going on at Fitchburg State College, he had lots to work out in terms of expert testimony. He could have worked with the Commonwealth's expert testimony, but he essentially never went into what is a mental impairment defense, and that's what he selected. That was his theory of defense, and he never developed it. He never hammered it home, and the jury and with the jury instructions, which they were proper jury instructions on mental impairment. There's no question. It's all this court has required, and there's language in one of the cases about all this court has required. It's a simple statement, and if that didn't go over their heads. He was ineffective in that. He could have done a much better job. And I realized that the courts do not require expert oratory in closing arguments. On the other hand, this may set a new standard for closing arguments in Massachusetts. And unless the court has any questions, I'll briefly touch on my last issue, or next to last issue. Defendant requested manslaughter instruction. And in the case, and there's an extensive discussion at the charge conference on it. The judge denied it. There were two theories of manslaughter: sudden combat and heat of passion. Sudden combat basically was that that the victim attacked him. And again, manslaughter is it's got to have. You don't look at the credibility. Okay.
What was there any evidence that this fight included any attack by
Oh, yeah, there was, at least according to the record, and that was the argument that John Gavin made. In the back of his head was one of the paramedics that was spongy, suggesting it was some kind of a bite by her. And then
Yeah, but you don't know when that was, right?
One can infer it occurred as a result of this incident.
Well, he was down there doing things to himself, right?
That was, again, he shot himself in the head too. Shot her, shot him. But again, that one would suggest that those are all jury questions too. I don't. I cannot tell this court what the chronology of what happened was, but it's in the record, and the judge was aware of it. He didn't go along with it.
But I mean, what did the judge have that would have suggested that he was required to give a manslaughter instruction? Well, can you just distill it for me in a couple of points so I get it?
He had a claim by a defendant that as a result of the victims attacking him, he became inflamed and committed murder and killed her. And this is based on the mental health does not play into manslaughter. Is a subjective and objective component, and the objective component is the objective person, and he subjectively had the reaction. Beyond that, it's fairly classic. Now, the Commonwealth in their brief went on in great detail about why this is not manslaughter, but nonetheless, that was John Gavin's argument. The second part was the whether this was heat of passion based on her most recent infidelity to him. And this, the case goes on, and the site, there's a lot of psychiatric evidence on this as well, of her wanting him as the boyfriend and not wanting him as the boyfriend. It went on back and forth. And the defendant's expert testimony was that he couldn't deal with it. And as a result of it, he became increasingly out of control, and this is what happened as a result. But nonetheless, that was John Gavin's theory on this one. It goes back to Commonwealth versus Schnapps with the communicating infidelity, and in this case, one doesn't know what she actually said to him, but the inference was it was in all the text messages. So those were the two theories, and that was denied. I would suggest that what actually happened would be more of a jury question, and he should have been given the instructions. Finally, and just in the last minute or so, let me talk about Section 33A. Even if, first of all, you got the cumulative error argument, but even beyond that, if you look at the entire case, it's not only is a very sad case for everybody, let alone the victim. We really had a situation where you have lack of criminal responsibility requiring mental disease and defect and all the other parts of the McCool standard, and then you get into this mental impairment, and there's really nothing in between. And this is a case where one could, if there wasn't lack of criminal responsibility, one could say it fell somewhere in the in-between category. And Massachusetts, by the way, Massachusetts does not recognize a diminished capacity defense. There's a case that says that. It's all mental impairment, which assumes, by the way, that the defendant is perfectly sane. Okay, just can't formulate the mens rea because he's either drunk or some mental situation. And you really have to look, this court, I would suggest, really needs to look at what happened in this case. And I think it calls for careful examination, because I think the outcome in this case was not consonant with justice. And unless the court has any further questions, I rest on my brief.
Thank you. Mr. Charles, good morning.
Good morning, Mr. Chief Justice, members of the court. My name is Jamie Michael Charles. I'm an Assistant District Attorney for Middlesex, appearing on behalf of the Commonwealth. With me at council table today is Assistant District Attorney Casey Sylvia, who is one of the trial attorneys in this matter. I'll start where my brother did in briefly addressing the ineffective assistance of counsel argument, and I would just quote to you from the trial judge's decision. Justice Billings concluded, after hearing testimony from Attorney Galvin, that he made a considered and reasonable tactical decision premised on a reasonable exercise of judgment by an experienced and capable trial lawyer who had thoroughly explored the issue. And I think that Attorney Galvin's testimony bore that out. And as this court is aware, where he was also the trial judge in this case, this court should accord substantial deference to Justice Billings' evaluation of Attorney Galvin's performance. So just to briefly summarize for you, Attorney Galvin testified that he did contemplate lack of criminal responsibility from the outset, essentially from the time he first encountered the defendant at Bridgewater in the aftermath of the crime, that he thoroughly researched the law on mental impairment, that he was aware of the Monaco case and knew that he did not need an expert, but that in his estimation, the absence of an expert, particularly on the facts of this case, would have drastically undercut the effectiveness of a defense, particularly undercut the effectiveness of his mental, and I did refer to it as diminished capacity in my brief, though I, again, am aware that it is not, strictly speaking, a diminished capacity defense.
But did he, two questions is, but the first one is, did he talk about the issue in terms of not being persuasive if he didn't have an expert in the context? Did he say anything about the Commonwealth probably will have an expert? In other words, was that part of the calculus? That it was going to be a no expert versus an expert, and it was going to be the defendant who didn't have the expert?
My recollection is that he did not specifically testify to that dynamic, though Justice Billings did acknowledge in his decision that obviously if there were a lack of criminal responsibility defense, there would have had to have been notice to the Commonwealth, and we certainly could have expected that the cross-examination of the defense—
Dr. Fife testify in this case?
I'm sorry?
Do I have the right case? Did Dr. Fife testify in this case?
She did, that's
Yes,
correct.
yes.
And I think one of the main sticking points in the motion for new trial was where there was no eliciting from the defense expert on cross, that this lack of criminal responsibility defense wasn't there, that sort of opened the door and distinguished this case from other cases. Dr. Fife did testify that it wasn't there, and I would submit, and Justice Billings again alluded to this, that the reason the Commonwealth didn't go there is because they knew there was no lack of criminal responsibility defense being espoused, and there wouldn't be a jury instruction on it. They had not gotten notice. And we can, and Justice Billings inferred that the proceedings and the flow of the case may have been different had there been a formal decision and notice to pursue that. So again, the Commonwealth draws a different inference from the fact that defense counsel retained 3 separate experts, a forensic psychologist, a neuropsychologist, and a forensic psychiatrist ultimately who took the stand, Dr. Brower. To the Commonwealth, that suggests that this reaffirms the idea that there really was no lack of criminal responsibility here. Neither of the 3 experts were willing to opine that was there. And I would argue, if you look at Dr. Brower's testimony, it really actually did provide a very firm basis on which counsel could build a mental impairment defense. He did testify that the defendant, that it's substantially contributed to his conduct, his personality. He just diagnosed the defendant with a personality disorder with schizotypal and borderline traits, which both Bridgewater and the Commonwealth's expert disputed, but nonetheless, that this caused the defendant to slowly lose control over time, that it affected his ability to exercise judgment and resist the impulse. That was a key distinction, I think, at trial, was an impulse that can't be resisted versus an impulse that is not resisted. I think, and the Commonwealth elicited testimony from Dr. Fife at page 133, I believe, of volume 10, drawing that distinction out because it was in response to the defense's mental impairment defense. The Commonwealth tried to establish this defendant was not mentally impaired. He was not inhibited by alcohol. He was simply someone who was in a state of anger and rage due to, excuse me, exterior circumstances, criminal charges pending against him by the victim, temporary restraining orders that had issued against him, his inability to make this relationship work, and that he just lashed out in violence, but that he made a decision to do that, not that he was incapable of controlling his conduct. So, but just to circle back, again, I would just say, I think if you read the testimony of Attorney Galvin, which Justice Billings credited, and this is actually this crystallizes it nicely, he said, the decision not to jeopardize a sound defense theory with a Hail Mary pass does not even seem questionable in hindsight, and that's Justice Billings on page 6 of his decision. So I would suggest that Justice Billings made the correct decision in concluding that this was not a manifestly unreasonable decision by Attorney Galvin to not pursue this defense. And I guess I'd rely on the cases I cite in my brief, which back that up. Turning briefly to the manslaughter defense, I would suggest that, as was alluded to by Justice Hines and some of the other justices when my brother was up here, it would be entirely speculation, which this court does not permit, particularly in the context of sudden combat, to infer that the victim initiated this fight and that any harm she did to the defendant was the impetus for this rageful outburst and this violent, brutal killing of Allison Myrick. The only testimony, and I'll just highlight it for the court for ease of reference, in the record, was that the defendant's statements to the paramedics, Deschler and Swenson, that the victim bit him in the head. And then there was testimony from Deschler, not corroborated by the medical records, that the defendant had a spongy area in the back of his head that did not appear to be the result of a skull fracture, but more of the pooling of blood. Now, there was no testimony linking the alleged bite to the injury in the back of the head. There was no testimony that the pooling of blood in the back of the head could not have been directly related to the pellet gunshot wound that the victim took in the front of the face, or to any of the physical wounds that were inflicted on her head and face by the defendant. There was no testimony, and it would require speculation to conclude that this bite, if it even happened, was, again, the impetus for what subsequently occurred in that basement, and that it wasn't just, as is more likely the case, the response to the defendant's violent acts toward the victim. So there really is no support for that sudden combat. I would just cite the court to Brown, 387, Mass. 220, for one of many examples where this court said the fact that the unarmed female victim may have briefly strangled the defendant with his shirt was not a sufficient provocation to justify his subsequent stabbing of her 27 times with a knife. As to heat of passion, I think all that really needs to be said is that this was not a sudden discovery. If you look at the testimony, volume 7 of the transcript at page 36, John O'Brien, the other individual with whom the victim was involved, testified that it was his understanding that that December 11th, 2009 incident at the Gulla residence, where the defendant had, I believe, punched the victim repeatedly and broken her phone, that that incident transpired primarily because the defendant read text messages between O'Brien and the victim on her phone. So he knew of the relationship then. Then 3-4 days before the murder, on January 19th, 2010, O'Brien testified, that's at page 49 of volume 7, that he was in the car with the victim when she put the defendant on speakerphone and they had an altercation over the phone, and the defendant, in fact, threatened to beat up O'Brien. So there was clearly not even just suspicion, but knowledge that the victim had this other relationship. And the fact that the defendant may have briefly entertained the notion that their relationship was back on the 22nd, and that ultimately proved not to be the case, does not fall within this narrow exception that we have to the rule that words are not enough to incite a heat of passion and warrant a manslaughter structure. So I would argue that Justice Billings made the proper determination after an extensive sidebar discussion at the close of the evidence that manslaughter was not an appropriate instruction in this case on either theory, and that the defendant is not entitled to a reversal of the verdict on that basis. And lastly, I would just note, for purposes of 33E, this first-degree murder verdict on both theories of premeditation and extreme atrocity cruelty was a just verdict. There was testimony that this was your typical domestic violence sort of pattern of conduct from multiple witnesses. Dr. Fife testified to that at volume 10, page 140, and there was testimony that the defendant's mother, when authorities responded to her 911 call after the incident, after the murder, she said to the first responding officer, there's a history of domestic violence here, and that's borne out by the record. Within weeks of the relationship starting, the defendant is kicked out of the victim's dorm because he's drunk and he's banging on doors. In October, he pushes her out of a moving automobile, and assault and battery charges issue as a result. In December, the aforementioned conflict at the house where the defendant, again, physical violence towards the victim, the defendant's mother feels compelled to call the police. She'd never seen him so angry. So this was an escalating pattern of conduct. It was not in any way an atypical situation, as my brother seeks to characterize it. And this defendant was acting in his own best interest out of feelings of rejection, out of anger over the temporary restraining order that was found open on his desk, the pending criminal charges, and the fact that this victim was ultimately making what I would characterize as a rational decision to walk away from her relationship with him.
Can I just ask you one question about the closing argument of Mr.
Yes.
Galvin? Did Judge Billings address that as part of the ineffective assistance?
I don't have the specific language he used, but yes, he did briefly address it.
Because it did
And his-
seem mighty short at the end there.
I would agree with the court that the specific discussion of the mental impairment expert testimony was relatively brief, but I think this court must bear in mind that the last witnesses that the jury heard were the two experts, and there was essentially an entire day's worth of testimony right before the closing arguments about the specifics of this mental impairment defense that the defendant was putting on. And while there was not, medical jargon used by defense counsel, he repeatedly emphasized this, he couldn't connect the dots theme. He tried essentially to do this in a layman's way that would be more relatable to the jury. This was a relationship saturated in alcohol. This was a relationship born in alcohol. The defendant couldn't connect the dots, and he acted in a violent, rageful outburst. So I would dispute my brother's characterization that this is setting a new low for closing argument. I think it was quite an effective one for a jury where we know that jurors are not always receptive to complex legal jargon. And I think he just tried to make it clear to the jury that, a normal person would have walked away from this relationship, and Robert Gulla didn't because he couldn't connect the dots. And I think that was an effective strategy on his part. I just think, given the facts of the case, given the violent nature of the homicide, given everything I've noted about the history of violence, and the defendant's clear consciousness and sober nature in the immediate aftermath of the crime, the jury just didn't accept that, and that was reflected in their verdict. So if there are no further questions, the Commonwealth's content to rest on its brief.
Thank you.
Thank you, Your Honors.